Good morning, everyone. I just want to let you know we'll be starting in about 3 minutes. So if you haven't heard anything yet, it's because we haven't quite started yet. Good morning, everyone. Can I get a thumbs up if you can hear me? Yeah, Adam, I'm sorry, you're the only one that I see in my thing. Most people have their cameras off this morning. Okay. It's nice to see. Thank you, Oscar. I appreciate that too. It's nice to see everyone communicating in the chat this morning.
Recording in progress.
Our training today is the LPS court process. I'm Vanessa Spyron. I'm the training manager for CAPA-PGPC. And on behalf of the association, we're happy to have you with us today. Before we begin, I would like to remind everyone, as most of you guys are aware now, we need to make sure that your full name is in the Zoom profile in order for you to get full credit for today. If you have logged in using the name iPhone or a series of numbers or whatever that does not have your full name, you will not receive credits for today's course. So be sure that your full name is on your Zoom profile. And this image here shows you that you can just toggle on these 3 little dots to rename yourself with your first and last name. So with that being said, let me go through my housekeeping slides. I did want to take a minute to remind each of you that we are offering induction academies, which cover our basics trainings courses, which are ethics, documentation, court accountings, INA, PA basics, and PGPC basics. These are all offered at no cost to you or your county through a grant with CDSS with our training grant. So we had one in Sacramento in January, one in Walnut Creek in February. We'll have 2 in April in Ontario. one in Sacramento in May, and then one in Fresno in June. And these courses just give you a chance to either get the material for the first time because you're either 1 or 2 years into your role, or maybe you need a refresher. And so people who want a refresher who've been there for a while are also invited to attend. It's a great opportunity. It's a small group, so it's a great opportunity to get your questions answered, talk through scenarios, and then also meet colleagues and network as well. So I encourage you to look into that and attend, and I hope to see you there. And again, they are in person. Okay, so let's talk about the training for today. As always, we ask that you're prepared with a link in the training materials before the start of the training, the day of. Participants are on an honor system. We ask that you are on time, and the training room is locked after 5 minutes. And you must attend the entire training to receive credits, and we highly recommend that you stay for questions and answers. After you do all these things, you will receive 2 credits for today's course as it's scheduled for 2 hours. And we would like to let you know that the training is being recorded. We are excited to bring you the training in a virtual training environment, and we have done a lot to make sure that it runs smoothly for you. But if we do have any hiccups or issues with the virtual aspect, then just please bear with us as we work through those. Again, please add your name onto the computer and or phone if you're calling in if you're joining us through a phone. If you are experiencing any technical problems, you can either send it via the chat specifically to Sarah, who's on with the association, or you can email the association if for some reason you get kicked out of the Zoom meeting room. Today, feel free to ask questions, offer comments and reactions. You can use the chat feature as well as the raised hand feature within Zoom as well. For today's training course, we will be taking questions throughout the training. You can be muted and unmuted by the host. If you raise your hand, the host will ask you to unmute and allow you to ask your question or make your comment. We will be taking a 10-minute break about halfway through. And again, if you're having any issues, you can email the association at info@capapgpc.org. Our learning objective for today is to ensure that PAPGPC professionals better understand the LPS court process and the public guardian's role in trial. Also, we have a disclaimer that we ask that you are aware this training provides basic training regarding the topic. Any information and or suggestions reviewed in the training is not to be construed as legal advice. So now I am happy to introduce you to your trainer for today. I'm going to stop my screen share. Feel free, Adam, to start sharing yours if you would like to. I want to tell you a little bit about your trainer for today, Adam Pressman. So Mr. Pressman did his undergraduate studies at Reed College in Portland, Oregon, and went to law school at McGeorge School of Law in Sacramento. Mr. Pressman retired from the Shasta County Counsel's office after 16 years, during which time one of his main assignments was the public guardian. While working with the Shasta County Public Guardian, Mr. Pressman attended numerous court and jury trials and was instrumental in conservatorship of Lee, which held that a trial court was not authorized to order the public guardian to file a petition for a Murphy conservatorship. So at this time, I'm going to turn the training over to Adam Pressman.
Hey, everybody, can you hear me, Vanessa?
Yes.
Okay, I'm going to assume that everybody else can too. Thank you all for joining me this morning. This is a topic I have enjoyed very much since I started the Shasta County Counsel's office back in January of 2007. And when I started in the role of a deputy county counsel, I had no idea what a conservatorship was. One of the things they asked me in my interview was, are you familiar with an LPS conservatorship? And I had to say, I have no idea what that means. You know, I figured that there was probably something in the world where people with mental illness were somehow taken care of. but I had no idea there was a thing called a public guardian or a public conservator, and I had no idea what the process was by which somebody was taken care of by whatever branch of the government that was responsible for it. So when I started, I was taking over the assignment from another county deputy, and I went to court with him the first week and sort of watched what he did. And that was in those days, our courtroom was just an office or a conference room in the mental health building. And the conservatives all submitted on the petitions. There wasn't a hearing, and everything went smoothly. And I figured, well, I can do this. I have my list of questions. I know what to do. And so I said, I'll do it next week. And I go to next week, and when I arrive there is a guy in a Star Trek uniform. And he is saying that he is William Shatner's son, and that he's authored a book, which I still have, on the care and maintenance of the Starship Enterprise. And I was sure at that point that my colleagues were playing a joke on me, that I had shown up and somebody put a person in a Star Trek uniform just sort of as a prank for me. And it was not. This gentleman was legitimately believing that. He was not at all a dumb person. He was not a bad person, but he had a very fixed belief in that he was William Shatner's son, that he knew all these things about the Enterprise, and things were going to be happening based upon his interpretation of the show and so forth. We did wind up having a court trial on that day, and the conservatorship was granted of him. And over the years, we had a number of other dealings with him. But that was a great experience, I thought, just to see how the process worked. And it really felt good. It felt like we were taking care of somebody who really couldn't take care of himself. I think the judge was very engaged with it. Most of the time, the people I worked with in the public defender's office were very good. And most of the time, I felt like the right result was often obtained, even if we won or lost. I felt like it was good to be able to have a hearing like that. So public guardian was one of my favorite assignments ever, and the LPS process was really my favorite part of the public guardian's office. I thought it was just fantastic. So I have a lot of respect for what you folks do and the challenges you face, and hopefully through today's training, I can make the court process maybe a little less intimidating, maybe a little bit more comfortable for you. I recognize that with everybody's court process, each county probably does it a little bit differently. And as Vanessa said at the outset, I encourage you to consult with your county council in the handling of any of the matters that are in your counties. They're going to know that process better than I ever will, having only shown up in a few different counties from time to time. I'll touch on that. But definitely I would defer to your county council. I don't think I'm going to be saying anything too terribly controversial here, but there may be something that your county council would disagree with. And again, I recommend you follow the advice of your county council and things. As Vanessa said, also, if you have any questions, let's address them at the time. Raise your hand or put them in the chat box, because I think that if you're having a question, perhaps somebody else is, and we can address it at that point. Let's back all the way out of things. When a conservatorship is, when a conservatorship is considered, you're first going to start with a referral, and sometimes it's going to come from the court. Sometimes it's going to come from a mental health director. Sometimes it's going to come from perhaps another source. But you're going to, as a public guardian, start the investigative process. You're going to go probably with, at least the way it worked in Shasta County, is one of the public guardians would go and visit the conservatee wherever they were placed, usually in a PUP. They'd go with a psychologist from mental health, and they would assess to determine whether or not this person met the criteria for a conservatorship. And if so, paperwork was started. A temporary conservatorship was put in place. A petition for a conservatorship was filed, and there was a hearing on that petition being scheduled. Sometimes that would be a hearing on a Murphy conservatorship. sometimes that would be, most of the time, it was a hearing on what we call a straight LPS conservatorship, where somebody was unable to provide for their personal needs for food, clothing, and shelter because of a mental disorder. I recognize that there's also the ability to conserve somebody who's not able to provide because of chronic alcoholism. We never had a case like that in Shasta County, so I'm not familiar with that process. I think it probably rolls out the same way as any of the other conservatorship hearings do, but that's something I'm not as familiar with, just having no experience with it. In any event,
Adam, I was just gonna say, you are not, I don't know if you know you're not sharing your screen yet. Did you want to be sharing it? Sorry.
yeah. Oh, thank you. Okay, well, let me see if I can do that. Does that help? Is that it?
No.
What am I doing wrong? Oh. Is that better?
There you go. Yep. It's perfect.
Okay. Okay. So we're on screen 2 there. That's the referral from the mental health director of the court. You've had your petition, it's been put on file. You're scheduled for a hearing date on your petition for conservatorship, and you show up at the courthouse for a hearing. At that point, there's a question, and the judge will pose it to the conservatee. Would you like to have me, the judge, hear this matter, or would you like to have a jury trial? And it's the conservatee's option as to whether he or she wants to have a jury trial. There is, if that's the case, the court will set a further date. Usually it's within a week or so of the day you're there for the first hearing for a jury trial. And conservatorship trials, as we were told in Shasta County, take precedence over everything. That is even criminal trials. Even a murder trial is put behind a jury trial on a conservatorship trial. Once the conservatee if the conservatee makes the choice for a jury trial, there's some pros and cons, of course, that go along with that. Some of the pros are that the jury process is perhaps some of the most, I don't know, what we would consider to be a very fair process. And so you have 12 people making a decision instead of one judge. And that seems to be a benefit for everyone, really, in exposing, the way that the government works and what happens with people who are in a situation like this proposed conservatee. Behind the scenes, the public defender and the conservatee will probably have had a discussion as to whether or not they want a jury trial or not. Sometimes the public defender and the conservatee would disagree, and if so, the public defender will have to accept the conservatee's request to go ahead with a jury trial, and they will proceed that way. It really is the conservatee's choice. The court trial probably takes around an hour, maybe sometimes less, maybe sometimes a little more, but it's a much quicker process than the jury trial, because in a jury trial, while you have the same standard of proof and the same elements that you need to prove in a jury trial, you can often take a day just to pick a 12-person jury. Everybody's given a number of people they can challenge without any cause, move them along, another person replaces that excluded juror, and you continue until you have seated 12 jurors and 2 alternate. That process, again, taking a day, you can have jury trials. I think the longest we had went 3 days. They were usually 2.5 to 3 days before we had the jury come back. Sometimes they would take the 3rd day and then come back on the 4th with a decision, but it's a much longer process than it is with a court trial. And also, one of the things about a jury trial is it's much more impactful upon the proposed conservatee. In a court trial, there's, the judge, there's a clerk, there's a bailiff, public defender, public guardian, the county council, the conservatee. a much more intimate setting. A jury trial, when it first gets started, you're going to have a room full of maybe 60, 70 people, sort of watching what's going on with this conservatee. And so for them, it can be uncomfortable. I've had an occasion where a conservatee said in the jury selection process, I want to change my mind. I don't want a jury trial anymore. Now I want a court trial. Because at that point, that conservatee didn't feel comfortable proceeding with that number of people around. Best guess, 75%-ish of the cases, maybe 50%-ish submit. Of the remaining 25 to 50%, the others will go to a court trial, and then maybe 5 or less percent of the time you're going to wind up in a jury trial. It just is not all that common. At least it wasn't that common in Shasta County. And for whatever reason, they would seem to go in waves. You'd have 3 or 4 jury trials kind of back to back, and then you'd go maybe a year without having them, and then 1 or 2 here and there. I don't know why that happened. It just sort of just seemed to be the way it would go sometimes. Again, the standard in either is the same, and that is whether or not the person is gravely disabled by reason of a mental disorder. One of the main things that you're going to see as in a jury trial that you don't see in a court trial are jury instructions. And the California Judicial Council has those listed on its webpage. I don't know if any of you had a chance to look at those over the course of your work with the Public Guardian's Office, but they're very helpful to see what it is that is going to be required at trial. They're the same things that are required in a court trial, but you don't have to instruct the judge. You're, of course, in a jury trial, you're going to have 12 citizens who, like I was in 2006 before I started, completely unfamiliar with the process, completely unfamiliar with how mental illness is treated. And I'm going to be talking mostly about the jury trial because basically if you're ready for a jury trial, you're ready for a court trial. But when you start to have jurors enter the courtroom and the judge gives everybody both sides the opportunity to question the jurors, basically with the goal of determining whether or not each of the sides feel that they have a jury that is going to be fair. And one of the things the attorneys will try to do is understand whether somebody wants to be there or not. There are a lot of people who say, I don't have time for this. I have X and Y and Z going on in my life, and I cannot spend 3 days in a jury trial. That person you probably don't want as a juror. In Shasta County, there would be a number of people who say, I don't trust the government one iota, and anything that the government says, I won't accept, and I don't think that we should be conserving people. And that person probably wouldn't be your best juror either. So we will ask, the Public Guardian or I on behalf of the Public Guardian would say, thank you, you're excused. There are a number of other people who might be good or bad jurors based upon their own experience with mental illness. Maybe they've had a family member, maybe they've had a neighbor, maybe they have known somebody with a mental illness and felt that they were treated well, felt that the government didn't need to be involved. Some were happy with the way the government was involved. And those types of people, depending on how they've answered things, might make them a good or a bad juror in your eyes, and maybe the eyes of the public defender might view it differently. Those are the types of things that are often going to be asked for of the potential jurors when determining who is going to make it onto the jury as some of the 12 are going to decide. The more difficult situation is because in a court trial, you're going to know that the public is excluded. So the public does not really get to come into your LPS court trial. But in a jury trial, and I think some counties may do it differently, but in a jury trial, you're already going to have 50 members of the public, 60 members of the public come in as potential jurors. In Shasta County, we would not exclude members of the public from sitting in on a jury trial because you already have so many members of the public there. I think, and I've heard through CocoNet, that's the county council's network, that there were some counties that were considering excluding the public from jury trials, and I just don't know how that would work. Maybe your counties do that, and if so, that's how your counties do it. I don't quarrel with that. We in Shasta County never did that because it would just be hard to make this a confidential proceeding when it is open to the jurors as members of the public to make the decision. When I came over to the county counsel's office, before I worked there, I was doing civil law, and there would be, in the course of a case, discovery. You'd ask interrogatories and depositions and so forth. None of that happens in a LPS proceeding. It happens very quickly. You put on your petition, and within 30 days, usually you're going to be at a court trial or a jury trial. And so there isn't really time for discovery in the formal sense. So what is really helpful to the attorney who's going to be trying the case from the county counsel's office and ultimately to the success of the case is how well the investigation is performed by the public guardian. What has been looked at to determine whether or not this conservatorship is appropriate? That family members been spoken with? Have doctors been spoken with? Will these people be helpful as witnesses? All of these things should be evaluated in determining whether you're going to be filing the petition and then whether or not you're going to want to proceed all the way through to a jury trial if you don't have all those elements in place. But the idea that you're going to be able to get better information through the discovery process, that's just not going to happen. There isn't time for that. The jury trial especially has two very important elements that we all want to recognize. First, we're talking about in an LPS proceeding about depriving somebody of some very important rights. The right to leave a facility, the right to not be forced to take medications. These are very important things. And so the law grants conservatees or potential conservatees these right for a jury trial. And it is a fundamental, it's fundamental to our way of doing things. We have a great system, I think, to make legal decisions, whether that be through a judge or through a jury. It's not a flawless system, but I can't really think of a better way to do it than ask members of our community to come in and decide disputes such as this. A dispute between a conservatee who says, I don't want to be conserved, and a public guardian who says, this person really does need help because they can't take care of themselves. The other thing that is important to recognize, and especially in a jury trial, is that your work is going to be put on display to the public. The manner in which you established a relationship with the proposed conservatee, how you interact with them, even in the courtroom. Does it appear to the jury that you are a good person in the handling of your case? Are you looking out for the best interests of your proposed conservatee? Are you fair in the process? The jurors pick up on very subtle nuances, and it is your opportunity to shine in front of the community, who in most cases probably are completely unaware of the work that you do. So it is a very good opportunity for you to present your program in the best light to members of the community who otherwise might not have the opportunity to see what you do. you might win, you might lose, but if the public comes away with the idea that there's a public guardian out there, they are in charge of determining whether somebody should be on a conservatorship, and here's what a conservatorship involves. We didn't feel like they met their burden of proof in this case, but we understand where they were coming from. That's not necessarily a loss. That's if you come away even without a conservatorship, if you come away with this case has shown the community what you do, and you've done it well, I think that's still a win, whether or not the conservatorship is granted. At the trial, there's a few things where your role is going to really be important. And one of those roles that you have is the transportation of the proposed conservatee to and from the facility. They can't get there on their own. They're often locked in a facility, so they're going to have to rely upon you to get them there. And one of the things we struggled with in Shasta County from time to time is we would have conservatees placed in very distant locations sometimes. We would have conservatees that were placed in Riverside, Los Angeles, Napa State Hospital. And getting those people to and from a multi-day trial was not going to happen unless we could find a local IMD that was going to be able to house these people for the interim of the trial. Otherwise, they'd have to go back and forth each day back to the facility in which they were placed. And if it's too far away, that's just not going to work. So one of the things we had to do on a number of occasions was go to Riverside or the satellite court in Palm Springs. We went to Los Angeles to hold trials. We went to Napa State Hospital to hold trials because there was no other way to do it. And if there is a way to do it, the public guardian's first function, or one of the first functions as it goes with the trial, is the transportation of the conservatee. And of course, that means making sure that the conservatee has his or her medications, has food or whatever else they might need to be comfortable, that they are potentially dressed appropriately. You know, if the person wants a tie, you know, make sure that they feel comfortable in whatever it is that they're wearing so that they can, you know, feel comfortable in front of the jury. That I think that's important for the public guardian to do. The public guardian is going to be sitting at the county or at the table with the county council. They'll be sitting up there and will be the face of the public guardian for the trial. Sometimes that person sitting at the council table will also be testifying. It's kind of nice if they do, because that sort of humanizes the person at the table in the eyes of the jury. But it doesn't have to be that person who testifies on behalf of the public guardian at trial. It could be somebody else. Or in cases there might not even be need for the public guardian at the time of trial to testify. It's really if there's something that the public guardian has that is important, whether, you know, the conservatee in chatting with the public guardian said, you know, I'm never going to take my meds, or I'm not mentally ill, I'm fine, I don't need medications. Those types of conversations could become relevant at trial, and it could be an opportunity for the public guardian to describe what's going on. The same with other issues that could come up at trial, and whether the person did or did not do some of the things that are the basis for the conservatorship. One of the things I was mentioning before, you don't want to have the conservatee showing up in hospital clothing. You want them showing up in whatever they most feel comfortable with, assuming that if the person can wear a tie, a judge or a doctor wouldn't say a tie is inappropriate. Let the person wear a tie if they can do so. Another part of the public guardian's role at trial, and it's very important, is establishing a rapport with other witnesses. There might be law enforcement. There might be family members. There might be staff members from the facility where the conservatee is placed. The public guardian, through their investigation, often will have had contact with these people. And it is very helpful for the trial attorney to be able to speak with these people in advance of their testimony. Generally, the rule in a trial for a lawyer is you don't want to ask a question of somebody you don't already know the answer to the question. So if the public guardian can say, this is law enforcement officer Jones, you have a chance to talk, the attorney has a chance to talk with Officer Jones, it is very helpful for the public guardian to be able to make that introduction. And even more so, I think, with a family member. See, in the course of your investigation, one of the things you'll probably be looking at is whether or not a family member is able to assist the conservatee, and that's third-party assistance. We'll talk a little bit about that in some of the coming slides. But sometimes the family members are wanting the conservatorship because they've been through a very difficult ordeal with the conservatee in the months or years leading up to it, and they know that they can't do it anymore. And so they can be very helpful in the time of trial to discuss some of the things that form the basis for the need for a conservatorship, and introducing the family member to your county counsel can be very helpful to help the county counsel in putting on his or her case and knowing whether or not this family member would be helpful at the time of trial. Oftentimes they're wanting the conservatorship, but they are nonetheless reluctant to be in trial because they're going to be potentially viewed as, adverse to their own family member if they're seeking a conservatorship or helping to get a conservatorship that the conservatee doesn't want. So there is some sensitivity there about trying to include family members as witnesses at trial. But with regard to the public guardian, it does help to facilitate the contact with the attorney so that the attorney can determine with the family member whether it's best for that person to come and testify at trial. All right. Your basic case. I'm not talking about a Murphy case. Murphy cases are a little bit different, but your basic straight up LPS conservatorship case is, well, is this person gravely disabled because of a mental disorder? And there's two ways to prove it. Can the person create a plan whereby he or she can obtain or meet his or her needs for food, clothing, or shelter? Or are they impacted in their ability to do so because of their mental disorder? Or does the person understand their mental illness well enough that they know that they need to take medications, and will they not take them and then become unable to provide for their food, clothing, and shelter? Those are the very basic forms of issues that are going to be in front of the jury. A few other issues, and we'll talk about those. But that's the big case there. Is that person gravely disabled because of a mental disorder? You're going to have to prove that to a unanimous jury of 12 beyond a reasonable doubt. We're going to be talking about proof beyond a reasonable doubt a little bit more in the process, but that is, in the law, it's the highest standard of proof. And as you're also probably aware, the jury is only there to decide grave disability. They are not there to decide issues related to what happens if a conservatorship is installed. Will that person be placed where, and what does that placement look like? Those things, the placement, the need for medications, the access to firearms and so forth. Those are what we call the disabilities. And the jury doesn't decide those things. Those are going to be decided by the judge if there is a finding of grave disability. So the first part of the trial would involve, for the jury, the issue of grave disability. Then if the conservatorship is found, there'll be a sort of a mini trial, usually just with a psychologist or psychiatrist from your mental health organization who testifies as to what level of placement the conservatee needs, whether he or she should be forced to take medications against their will, whether he or she should be allowed access to firearms. Interestingly, and I think I'll discuss it again in a future slide, there's a jury instruction as to whether or not the conservatee should be deprived of the right to vote. But that, I'll talk about that again in a little bit. We recognize that a juror is going to be wondering what happens if I vote for grave disability. What's going to happen with this person? And the jury is specifically instructed here not to consider that, but they do. And it is for everybody in the room, everybody's wondering what's going to happen. They're told they can't do that. And one of the first things that they will ask after the trial is over, especially if they're conserved, is what's going to happen to this person? Where are they going to be? What's it going to look like for them? Because they're all very concerned about that. There's not a lot we can do about that concern, except ask them to follow the law. And the law, as they will be instructed by the judge, is you are not to consider that. So they're sort of told to put it out of their mind. I doubt that they really do, because again, it's one of the first questions that are asked when the trial is over and we meet with the jury afterwards. Third-party assistance. It's the law finds that somebody is not gravely disabled if their needs for food, clothing, and shelter can be met through a third party, and that's often with friends or with family members. And this goes back to your investigation as public guardian. We've heard the person who says, I don't need the conservatorship because I'm going to have my mother, my brother, somebody, my good friend, take care of me. And their statement to the judge or the jury isn't good enough for that. The person who is going to provide that third-party assistance is required to either appear in court or provide something in writing stating that. And it is also, I think, on the part of the public guardian, a good idea to actually go out and verify that person. Is that person a meth head living in a trailer someplace who's offering to do this so he or she can get the conservatee Social Security money? Or is this a bona fide family member who is legitimately willing to help, take care of the person, recognizes the need for medications, knows how to calm the conservatee when things get a little rough, provides a safe place with adequate supervision to ensure that the conservatee is getting his or her food, clothing, and shelter. If you have that type of person and they come and testify at trial and they're believable to the jury, that person's not going to be conserved because third-party assistance will carry the day, and the conservatorship won't be necessary in the law, in the eyes of the law, when that third-party assistance is met. On the contrary, of course, if you do have some sort of sketchy person who looks like he or she is on meth and has a bad background, the jury might look at that and say that's not the appropriate person to be making sure this person has food, clothing, and shelter. And even if the defense is put on by the public defender, that might not be enough for third-party assistance, and the jury could still award the conservatorship, notwithstanding this offer of third-party assistance. One other thing that goes along with that is that a correctional facility does not count as third-party assistance. If that person is, for some reason, incarcerated, you probably don't want a conservatorship anyways. But if the person is saying, "Oh, I'm going to be in jail. I gotta. If things get rough, I will just show up in jail and ask to be placed there so I can have my personal needs met." That's probably not going to be enough for a conservatorship. That will not be third-party assistance. I do see. I see there's a question here. Is there any legal accountability of a third party if granted and then they change their mind and discontinue their assistance? That's a very good question. All right, so let's say you go to a jury trial or a court trial, and along comes a family member who says, I'm willing to take care of that person. And in the course of the conservatorship is not granted on the basis of that person's willingness to provide third-party assistance, and then things go badly. The conservatee runs off, conservatee gets into the liquor cabinet, and something bad happens. Will the third party, have any legal accountability? And they might. If they are aware that a person is in need of medications, not providing medications to that person, and maybe for whatever reason, and a bad result happens to the conservatee, who won't be a conservatee, but to that person, potentially the third-party assister may have some liability to the conservatee in a situation where he or she did not provide adequate assistance. And that would be something for those two to sort out. Public guardian wouldn't be involved. But if the person was providing third-party assistance and they don't continue or they do badly in that role, the conservatee is picked up. I keep calling them conservatee, but you know what I mean. If that person is picked up on a 5150, the whole case kind of starts again. And you go through the investigative process, the person's in a puff, you start up with a brand new trial. And if that person shows up again offering third-party assistance, their third-party assistance is probably not going to be viewed as very worthwhile or worthy, given the failure that occurred on the previous situation. They might come in and say, I know how to fix it now. And that would be for the jury to decide whether or not that third party's assistance is actually viable. But I hope that answered the question. Let me know if we can give some more details about that. Good question. All right. One of the things that we will be touching on, or the jury will be asked to consider in the course, is the history of the disorder. And that history can be important to the jury, and they get to decide whether or not that history is relevant to the need for a conservatorship. So you have a conservatee who's been 5150'd 4, 5, 6 times in the previous months. And each time they can, the medications that are provided for conservatees or for people with mental illness oftentimes work very well. And they work so well that people start feeling so good that they don't feel that they need their medications. Then, of course, they go off their medications, and the same problem that the medications were solving reemerges. And you'll have a situation where a person says, okay, I'm going to take my meds, they go off, they become 5150 again, they cycle through. That sort of history is very helpful to a jury in deciding whether or not that person, for example, recognizes his or her own need for medication to help his mental illness or her mental illness. I've had cases where that exact thing has happened. Person gets 5150, maybe 5250, they clear up during the process. There's no more need for the hold, and off they go, and only to return again within a month. perhaps on several occasions. That kind of history, again, is very relevant to a jury. The history of the disorder can often be, just a second, I have a question here. Since local rules vary by county, what do we do when court or PG denies a third party to testify and submit written statements about their willingness to help? We are told that if, per the Welfare and Institutions Code, we are told that if conservatee objects, then the court can exclude third-party statements. Well, let's see. If I'm understanding the question right, the question is if the conservatee doesn't want that person as a third party for their assistance, can the conservatee exclude their statement saying that they will, the third party's statement? Yes, I think that's probably true. That is, the court, if the conservatee is unwilling to go with that potential third party, then whatever mom says doesn't come in. Now I see a follow-up. They're basically saying, I don't want my mom to submit statements about my history, and the court excludes it, even if that history or assistance is key to the case. Now that's a different story. Okay, so if the mom has history about the case, about the conservatee's unwillingness to take medications or, you know, some other relevant information, and the conservatee objects, there's going to have to be a good basis for the objection for that not to come in. Whether it's a hearsay objection, whether there's some reason the mom might not have known the medications weren't being administered. The conservatee can object, but there's going to have to be a good reason for the conservatee's objection before it will be sustained. And if you've got a mom coming in and said, I was giving these medications to my son or daughter, he or she looked at them and said, I don't need them, I'm not going to take them, I'm not mentally ill, I'm fine. That mom's testimony, I think in most cases, is going to be admissible, whether or not the conservatee objects to it. Hopefully I answered your question there. You might have questions not only from or a history that comes from a family member, but also from law enforcement. You might have history that comes from other medical providers who've seen the conservatee over the years. And that gets a little bit tricky because there's now some new case law that's been developing over the past 5 or 6 years. That we used to be able to take an expert and have the psychologist, for example, say, over the course of time, this person would take their meds for a little while and then go off their meds because they didn't think they needed them. And the law allowed at that point, until 5 or 6 years ago, for the psychologist to testify as to all of that. And then along came a new case, it was called Sanchez, and it says, experts can't just bring in all this old stuff from other folks and basically testify to somebody else's opinions in front of the jury. If you want those opinions in, and somebody who is a witness in that regard, you've got to bring in those other people. They can't be testified through the hearsay of the testifying expert. It made life much more difficult in proving these things because of the requirement that you involve a number of additional witnesses, sometimes who might no longer be available. The doctor may have retired or moved or something like that. So the history of the disorder is very relevant, but it creates a very difficult situation in gathering that information in a presentable format for the jury, given the difficulties in locating and then bringing in other witnesses. I mean, the other witnesses might have been in a different location than you're at. This person may have had conservatorship in a distant county, and you're going to be talking about bringing a healthcare provider in from Southern California into Shasta County. Again, that creates a great level of difficulty in the presentation of the case that didn't exist before the law developed, that your experts can't rely upon things. The public guardian's role in this, again, is critical, because you will be able to, through your investigation, hopefully find these other witnesses, find these other records, and then in working with your county council, determine whether those witnesses can be made available and whether they would be helpful to your case. I think I've touched on this one already. This is the jury's role in the process. And the jury, again, is there to decide the issue of grave disability only. There is a section, one of the instructions from the jury instructions that allows the jury to decide whether or not the person should be deprived of the right to vote. We in Shasta County never thought to eliminate anybody from their voting eligibility, so that never became an issue for us. I don't know if other counties do that or not. Basically, if the person wanted to vote, we weren't going to deprive them of that right, and we never got any blowback from the public defender or the proposed conservatee of the court. I think we would have, in a lot of instances, had we tried to revoke somebody's voting rights. But again, the jury is simply deciding the issue of grave disability and not the other issues of disability, such as medications and placement. All right. Proof beyond a reasonable doubt. The law has in it a number of different standards, and some of those standards for the requirement of proof vary, or they all vary. The burden of proof in a conservatorship grave disability issue is proof beyond a reasonable doubt, and it is the highest level of proof required. It's the same level of proof that is required of in a criminal trial. But really, what is that? What are you going to have to prove in order to achieve the conservatorship of this person? The instructions define reasonable beyond a reasonable doubt as having an abiding conviction, and I'm not sure that helps very much. The law will recognize it is not a proof of the elimination of all doubt, but the elimination of reasonable doubt. And jurors struggles with this, lawyers struggle with this. The best way to put it, I think, is if you are saying, gosh, I think it could be this way, or maybe it could be that way, you haven't met your burden of proof. If the jury is sitting there going, I'm just not really convinced, then the burden of proof hasn't been met. And the public defender will make great use of this instruction, the requirement of proof beyond a reasonable doubt, because it's what we have to show, and they will be showing what a very high burden that the public guardian has to reach in achieving things. Sometimes people will talk about, the scales of justice. And in the civil law, you just need a preponderance. One grain of sand in the liability side means, you carried your burden. And in the conservatorship or the criminal case where it's proof beyond a reasonable doubt, scales are pretty heavily, you've really got a heavy burden. You got a heavy burden of proof to show on this side. I know that doesn't help a lot, but that is what the jury's going to be asked to do. I see there's a question here. I don't know, Vanessa, if we're at a spot we'd like to take a break now, or then I'll come back and answer the question, and then we can resume with that. How's that sound?
I think that's a great idea. And I'll point out that when you first started, there was another question that came in there as well. So just if you'll check the chat during our break and make sure that you see all the questions, and we'll address those when we come back from the break. Are you good to start back at 10 after?
Yes, let's do that.
Okay, so we'll have a quick break, everyone, and come back at 10 after.
All right.
All right.
Hi, everyone. Real quick before Adam gets started back, I do want to remind you that if your full name is not in your Zoom profile, that you cannot receive full credit for today's course. And if you have any questions, if you're not sure, if you're just showing a series of numbers or initials or not your full name, then you may want to send Sarah with the association, send her a direct message. Otherwise, you need to make sure your full name is on your Zoom profile. So thank you for that.
Okay, I'm ready. You can hear me still? Okay. I'll turn to the questions first. The first question was, can the investigator interview the proposed temporary conservatee before the petition for temporary conservatorship is personally served on the person? I didn't look at this question specifically in preparing for this, so I'm gonna go with my probably answer, and that I would say that's probably yes, and that is it's a free country. You can talk to whoever you want to and who you don't want to, and the conservatee or proposed conservatee can do so as well. It would seem that in filing for the temporary conservatorship, one of the things you will have wanted to do would be to talk with the conservatee and see what is going on with them. And so my gut is telling me that yes, you should be able to talk to that person to determine whether or not the conservatorship is necessary. But if they don't want to talk to you, they don't have to. Hopefully I have that right. I would double check with your county council on that one, because that was not something I was really prepared to address today. The other question that came in is dealing with the issue of guns or weapons. The question is, if someone's mental health is confidential, then if they want a firearm, isn't it easy to obtain one? And to be more clear, how does gun shop know if someone is in the mental health system? When somebody is 5150'd in California, I don't know about other states, but in California, there is a record created with the Department of Justice, and that record would prevent a gun shop owner from selling to that person. They then are become ineligible for the purchase of a firearm through a licensed gun dealer. And I'm not sure what information that the gun shop owner receives. That is, do they find out the person was 5150? Probably not. I think what the gun shop owner probably receives from the Department of Justice is something saying Bob Jones is ineligible to purchase a firearm. I think that's I think my best answer on that one. Another question. So the gun shop. So does the gun shop have a list of conserved clients? No. I do not think that those are still confidential records. The records of conservatorship, the records of 5150. Those are not publicly available to gun shop owners or to others. So they would not be given that information. I think what the gun shop owner would probably be receiving is some notification from the DOJ that says, this person is ineligible for the purchase of a firearm, and not knowing why. And I think that's only 5150. I don't know that the public guardian forwards any information about a conservatorship to the Department of Justice that would otherwise disqualify somebody. But 5150 is a 3-day hold. So that's how long the 5150 applies. But the prohibition on the ownership of weapons, I don't know how long it lasts for them. It might be something that the conservatee, I think, or the person who is 5150 has to go back into the Department of Justice and show that they have now recovered from whatever incident that caused them to be 5150, and they are now again eligible to purchase firearms. So I think that looks like with your county council, but I think that the way it goes is somebody's found to be 5150, the Department of Justice is notified, and then the Department of Justice issues a hold on their ability to purchase firearms. That hold is then lifted when the person who is the subject of the 5150 goes back to the Department of Justice and satisfies them that they should now be eligible to purchase firearms again. Good questions. Thank you. All right. I think as we talked earlier, there were going to be 2 ways to prove grave disability. One of them is the person who's unable to meet their personal needs for food, clothing, and shelter because of their mental disorder. That's the person who comes in and says, I am a billionaire. My father is William Shatner. I'm going to go live with him. I have 3 houses in Bel Air and another mansion in Aspen and a large apartment in Manhattan. I've got a place to go live. I've got billions of dollars with which to buy food and clothing. I'm fine. So I don't need a conservatorship. I can take care of myself. And what you're, of course, hearing is delusion, that they can't meet those personal needs because they don't have the mansions and the hotels or the billions of dollars. And the public guardian in that case would do a rudimentary investigation, perhaps, ask for their banking information, ask for, where their houses are located, and should be pretty easily able to establish that the things that they are talking about are the product of their mental illness and not a reason for them not to be conserved because they can provide those are actually the easier cases in which to obtain a conservatorship. And generally, at least my experience here in Shasta County, is that those cases are not usually the ones that wind up going to a jury trial because the public guardian, the public defender talks to the conservatee and gets he or she to at least just accept a court trial. Every once in a while they wind up in a jury trial, but that is not the more common way for a jury trial to occur in a conservatorship case. The more common case is the second element up there. That is that the person will not take their medications and is unable to provide for their food, clothing, and shelter without their medications. Those are the tougher cases to prove. And that, what you'll see, even if these are the cases that we've had the most trouble with. So somebody will be 5150 on and off for a number of times, or even on and off conservatorship for a number of times. And each time the hold ends, they very quickly stop taking their meds and are then become severely mentally ill, severely symptomatic, and wind up, taking off their clothes and jumping in the river or doing some other kind of erratic behavior and winding up again 5150. And at some point, everybody says, that's enough. We're going to place you on a longer hold for your own good and for the good of, the community. The person will then, the more difficult case involves the person who then comes in and says, I know, I had a bad patch with my medications. I didn't think that I needed them. I have now, after 5 5150s in the past year and a half, come to learn that I do need my medications and I will faithfully take them. And we, in the public guardian and the county council, have to then put on a case beyond a reasonable doubt that shows that this person still doesn't understand and that they will not take their medications because they do not understand their personal needs or the nature of their mental illness, and they are being untruthful. And we have to show that they are then presently, that is not in a week they'll become gravely disabled, but they are at that point, at that very moment in the day, presently gravely disabled when they're telling the jury that they are going to take their medications, that they know they have a mental illness. The medications keep them from being symptomatic, and they don't want to be symptomatic, so they will take their medications. And we've had cases where we've had a conservatee who beat a 5250 writ, was released, went out within days, was off his medications, and came back and gravely disabled again, unable to provide, very psychotic. And we pointed out that here's your testimony at this previous trial. You said you understood that you knew you needed your medications, and you within 3 days were 5150 again. And he said, I know, I did those things. And I now I understand all the better. So I have to, so I know I have to take my medications because of the bad things that happened. And that person won their trial. And I think I'm okay with that. Those are the hardest cases to win. And I think the law is set up for it to be difficult for a conservatorship to be established. The law actually says the LPS conservatorship process is to be used sparingly. And so if the person can convince the jury, and they have to convince the jury that they understand their need, and the jury might well say, I don't think you understand it because of what's happened in that history. If they are able to convince the jury, that person's going to prevail on that request for a jury trial, and they're going to leave the courtroom at the end of the day and without a conservatorship in place. And then we will have to see what happens. By and large, my experience was those people come back. If they were to remain in Shasta County, we would see them cycle through again and again until eventually there would be a longer conservatorship for a year put in place. And probably at the end of the year, we would not renew the conservatorship, and they would go off conservatorship without prevailing on a trial, and we would see what happened. Sometimes they'd come back and sometimes they wouldn't. But those are our hardest cases, the ones where we have to prove present grave disability beyond a reasonable doubt, based on the lack of understanding of the need for medications to treat their mental illness. Those are the hardest cases. All right. The verdict. When the case is all complete, the jury will be read all the instructions by the judge, and then they will be able to take the instructions with them and any of the exhibits with them into the jury room, and they begin deliberating. And everybody sort of makes a side bet as to who they think the foreperson of the jury is going to be. None of us ever really win. There's nothing to win, but it sort of keeps everybody sort of interested. And they go back, and sometimes it's a very quick process. Sometimes if they get the case at the end of the day, they will come back the next day and deliberate. I've not had a jury, I can't remember if I've had one go out for more than 3 hours-ish. Sometimes they came back a little quicker than that. But the thing that the jury is going to be asked to decide again is the issue of grave disability. And for the grave disability to be found, all 12 of the jurors have to agree that the person is gravely disabled because of their mental disorder. And if the alternative 9 jurors find that the person is not gravely disabled, then they prevail. They beat the case. They are not gravely disabled. And if you have something less than those numbers, 6 saying gravely disabled, 6 saying not gravely disabled, for example, you have what's called a hung jury. And that jury will be dismissed. They will be thanked for their service, and you will start up all over again with a new jury, and you'd basically be putting on the same case again. I had that happen once. We had I want to say it was 10-2 in favor of conservatorship, and we had a hung jury. We came back and we continued the case for a couple of months later. The person remained in the IMD. We came back and tried the case again, and they won that time, saying that they better understood their need for medications and that they would take them, and they were found to be not gravely disabled, and that case went away. That person was not conserved. And in the years that I remained doing the public guardian work, I don't think that person came back. So I'm not sure whether he or she moved or whether he or she started to understand what they needed to do to take care of themselves. I just don't know what happened, but that was my experience with the hung jury anyways. When the verdict comes in, there's of course 2 things that are going to happen. I see a question. How often do juries vote gravely disabled versus not gravely disabled? I want to say, I think we probably had 10-ish trials in the years that 10-ish jury trials in the years that I was with the public guardian's office. And I want to say we might have won 6 out of 10 of them. Maybe we won 5 out of 10 of them. I'm trying to remember. But the ones, so that's my experience. When you get to a jury and you've got the question of whether or not that person presently gravely disabled beyond a reasonable doubt, when they're saying they know they're going to take their medications, those are the ones that we lost, and those were, I understand why we lost, because they didn't find that person was still presently gravely disabled. Your experience may vary. Different counties may do more jury trials and may have a different ratio of results. I want to say ours were about 50-50. On the court trial, on the other hand, I want to say our conservatorship result rating was way up in the upper 90. We would have conservatorship trials. I can think of a handful that the finding of grave disability was not found, and we would do, we did hundreds of those over the years that I was working with the public guardian's office. So jury trial is a much harder thing to get past, at least a Shasta County jury, the idea of grave disability, than it is to prevail in front of a judge in Shasta County. Again, I see this is from Paul in Fresno. Paul, your experience down there may vary. I'd be interested in knowing what sort of results that you get down in Fresno. But what will happen after the jury is done is there'll be 2 findings. One, the person's gravely disabled, and then that person gets taken with the public guardian to whatever facility the judge has identified as appropriate for them. And or the conservatee is found not to be gravely disabled, and it could be a raining cold day. It could be 108 outside in Reading. It could be 112 outside in Reading. And that person is going to walk out of the courthouse into wherever. without, they'll say, I've got a plan to go stay at the motel down the street. We don't know if they're going to do that, but that's what their right enables them to do. Should the public guardian assist them at that point? They can. And we might feel that the jury's verdict was wrong. We might feel that the person is going to go out and get a bunch of drugs and, be in a bunch of trouble before the sun rises the next day. We really can't do anything about that. I do think it is fair that if a jury trial is unsuccessful and we've had a conservatee who has his or her things that are at the IMD, I think it's fair to take the person back to the IMD so that they can gather their belongings and go off. I don't know if that's technically required, but I would sure encourage the public guardian to do that. It seems a little unfair to force somebody to come to a trial that they then win and then make them have to get back over to the place you made them leave their things at to go pick them up and resume their life. So I think it is fair for the public guardian to transport the person back to whatever facility they were at to allow them to gather their belongings, and then they'll go out the door and do whatever they did that they want to do, because the public guardian will have no more ability to control their movements unless and until something else were to happen. Ladies and gentlemen, I think I've arrived at the end of the presentation, but we still have time for questions if anybody has any.
Yeah, and Adam, I think there were several that came in through the chat from some of the conversation from earlier. So if you go up to around, starts maybe where Heather had a comment about 5150 hold and purchasing guns, that conversation.
Okay. Oh, okay. Heather is saying the limit after being on 5150 is 5 years before an individual is able to purchase a gun. But since January of 2020, if they're placed on the 5150 more than once in a 1 year period, they're unable to purchase a gun for life. Thank you, Heather. I wasn't aware of that. Thank you. And there's Clint has shared W&I 8100 with firearms information on it. And Roger has shared that there is a petition to restore gun rights under 8103 of the Welfare and Institutions Code. Kim shared that there was a person found out not greatly disabled, then a month later killed his mother. Sorry. If a person disagrees from Galaxy, the question is, if a person disagrees with the verdict, can they just file an appeal? And yes, they can. The hard part is challenging a jury's verdict is going to be hard. If a jury has heard all the evidence, the jury's decision is going to be very hard to overturn. The question usually on appeal is whether some evidence was admitted improperly or excluded improperly. So if somebody came in and said, here's my third party assistance, and for some reason the judge said, I'm not going to allow that, that would be an issue on appeal. If the judge allowed some hearsay evidence in, and that was found to be material to the case, that would be an appealable issue. So usually, or if perhaps some instruction were issued, not one of the standard instructions that I identified that come from the California Judicial Council, but say some special jury instruction were created and that were found to be improper, that would be another basis for appeal. Generally, however, to challenge the jury's decision itself is a very difficult thing to do on appeal. You'd almost have to show that somebody on the jury was perhaps biased, or they flipped a coin to arrive at their verdict versus deliberating over the evidence or something like that. I think there is the opportunity for an appeal, and the success of the appeal would depend on the nature of the issue that is being brought up on the appeal. And I think there's a question from John or comment. During my 7 years, can I recall a jury verdict other than one finding grave disability? Court trials almost always find, but there are occasional ones that go the other way. Yeah, John, that's been my experience as well. That it's very common for the judge to find it, not at all as common, not at all a sure thing when the jury does that. Thank you, Ewan, for your nice comment. Roger, most jury trials in Los Angeles County find not grave or disabled, as I noted. After the trial, jurors usually ask what happened to the client, with so much information regarding the client and what the conservatorship entails is limited. Yes, Roger, also true. Probably it's interesting to know that Los Angeles is having, a similar result with regard to the jury trials that take place there. Well, again, everyone, I want to thank you for being a wonderful audience. I hope I was helpful to you in some regard. If anybody would like to contact me, Vanessa has my contact information. She's welcome to share with anybody messages. Okay. Thank you.
Adam, would you be willing to put your email address in the chat?
Yeah, here, why don't I just do that?
Okay. Yeah, that would be awesome.
Very good.
And
more than happy to help you.
Yeah, I will ask if anyone has any more questions as he's doing that. Again, feel free to type it in the chat or to raise your hand if you'd like to come off of mute. But I think this has been a very, very informative presentation. I know that I learned a lot, so I hope that you guys have as well.
Yes, thank you all.
Are there any questions for anyone? Oh, Adam, did you get a chance to put your email in? It might have gone specifically to someone.
I thought, I probably put it to, I probably did that. Okay, I think I just sent it. Leah Polliner has it, but I make it go to everybody.
I know, I do that often. While he's doing that, I just want to remind everyone, we do have a couple of other virtual trainings coming up. The next one is on March the 21st. It's called Self-Care Work and Well-Being, Finding the Balance on Caring for Yourself While Caring for Others. You guys work really hard and should gain the opportunity to institute self-care and knowing how to care for yourself as well. So please don't forget that one. As well as Mr. Pressman will be back on April the 4th for Death of a Conservatee and final distribution as well. So those are our next two coming up, and we'll have a few more coming out. If you have any questions about the academies, feel free to email myself or the association at the info@capapgpc.org email address. And I don't see any more questions that have come in. So Adam, I just want to thank you immensely for being with us today and sharing your knowledge. And on behalf of the association, I thank all the members for being with us as well. So everyone have a great day.
Thank you, you too. Bye-bye.
Recording stopped.